That's a new feature. So welcome everyone to a conversation with Tas Khalid, who is a solicitor with JMW. My name is Emma Smith. I'm the project manager with Empowered Conversations, which is an Age UK Salford project. As some of you know, some of you might not know, we deliver communication courses for family carers of people with dementia across Greater Manchester. We've just piloted a new course called Moving Beyond Words, which is a follow-on from Empowered Conversations. If you want to find out more about that, ask me. We also offer one-to-one support in Salford through Empowered Carers. And as a result of the pandemic, we've been doing loads of online stuff, and the webinars are just one of those things that we've been doing. So the format for today is you've had my blurb. I'm going to hand over to Tas shortly, and she's going to do a presentation to you and a talk. We'll call it a talk rather than a presentation. We've got a Q&A function at the bottom of the screen. So if you have any questions at any point, drop those questions into the Q&A and we will make sure that we've got time at the end to pick those up. I think that's all I've got to say, so I'm going to hand over to you. I'm going to say thank you so much, Tas, for giving your time today and for joining us on the webinar. I'm going to hand over to you while I drink my cup of tea.
Thanks, Emma, and my pleasure. Good afternoon, everyone. So I'm just going to share my screen. There we go. I'm going to pop it into presentation mode and hopefully you can see that okay. Great. So thank you for the introduction there, Emma. So I'm Tas Khalid. I'm a solicitor and head of the private client department at JMW. I've been providing legal advice to those living with dementia, their families, their carers since 2005. Mainly offer legal support in relation to financial matters, but we do teeter on health matters as well. But the bulk of this presentation will be teetering around the financial matters such as wills, powers of attorney documents, the role of the Court of Protection and the Mental Capacity Act. I do want this to be conversational, so if people do have questions, then more than happy to offer any support that I can there. Okay, so I was having a little look at the recent stats in relation to dementia. And I was surprised that the numbers have risen so much. So in 2014, there were 850,000 people living with dementia, and this is due to increase to over 1 million by 2025. I've been dealing with it on a personal level. Unfortunately, I've had a number of family members who've been diagnosed, but then also on a professional level, on a weekly basis, we are dealing with such queries. So financial legal affairs of people living with dementia. What we get often asked about is the Mental Capacity Act. How does dementia alter or affect people's decision-making abilities? We also get asked about wills, powers of attorney documents, and the roles, like I said earlier, about the Court of Protection and the Office of the Public Guardian. So I'm going to start off with the Mental Capacity Act 2005. This act sets out 5 fundamental principles which we must all adhere to. So I just want to go through these in a bit more detail. So first of all, a person must be assumed from a legal point of view to have capacity unless it's established that they completely lack capacity. So a diagnosis of dementia does not automatically mean that someone doesn't have the mental capacity to make decisions for themselves. It is possible for a person to have capacity to make certain decisions and not others. Capacity is accessible on a decision by decision basis. Principle number 2, a person is not to be treated as unable to make a decision unless all practical steps to help them to do so have been made. So every time a decision needs to be made about a person, they should be given as much support as possible to be able to make that decision. This may involve communicating using pictures or prompt aids to help them to make their own decisions insofar as possible. The starting point. Principle number 3. A person is not to be treated as unable to make a decision merely because they make an unwise decision. So what may be unwise to me or you or Emma might not necessarily feel unwise to that individual. So where my mother decides that she wants to cut out all of her children and she wants to leave everything to the donkey sanctuary, that is her choice to make, as long as she's got the requisite capacity to make it. Number 4, an act done or a decision made on behalf of a person who lacks capacity must be done so or made in their best interests. So when it's ascertained that an individual living with dementia has actually lost capacity, all future decisions must be made taking their best interests into account. And that principle is quite paramount under the Act. And finally, principle number 5, before doing an act or taking a decision, regard should be had to whether the desired outcome can be achieved in a way that is less restrictive of the person's rights and freedoms. And that's the principle of there is to treat everyone with dignity and respect, and to empower individuals insofar as possible to make their own decisions. Now, assessing capacity. Who and when and why does this need to take place from a legal point of view? So capacity should be assessed every time a specific decision needs to be made. So on a decision by decision basis. A person is deemed to lack capacity in relation to a specific decision if at that pertinent time they're unable to make the decision themselves because of, for example, an impairment of the mind. A person is taken to be unable to make a decision for themselves if they are unable to understand the information relevant to that decision, retain the information, use or weigh that information as part of a decision-making process, communicate their decision by any appropriate means. So if a family member or a carer feels like or is in doubt as to whether a loved one or an individual that they're caring for does or doesn't have capacity, they can consult other professionals within this field who are experts in assessing capacity. That may be a doctor, maybe a solicitor, it might be another capacity assessor in their professional role. If having followed the fundamental principles of the Mental Capacity Act 2005 and applying the test that I've just outlined there, an individual is deemed not to have capacity, then the next step is we look at who has the legal authority to make a decision on their behalf. There may be a legally appointed attorney under an enduring power of attorney document or a lasting power of attorney document. If there is no power of attorney document, there may be a deputy appointed by the Court of Protection. And if there is no one who is able to make a legal decision on their behalf, then an application can be made to ensure that from a legal point of view, there is the appropriate person to be making a decision on their behalf. So in terms of some basic financial housekeeping, and I've put there for those with capacity in inverted commas, everyone should have a will. And the making of a will is a positive act which allows your loved ones to benefit from your estate after you pass away. If an individual doesn't have a will, then the law dictates who's going to be entitled to what. So the law states, it's called the Intestacy Rules, that your closest blood relative will inherit your estate if you die without a will. Or if you're married, husband and wives are entitled to a proportion of the estate depending on values, and thereafter the blood relatives. So it is a positive act which is encouraged. Everyone should have 2 powers of attorney documents. With powers of attorney documents, you nominate an attorney, a legally appointed attorney, to act on your behalf, to step into your shoes and make decisions in relation to your welfare, your health and welfare, and your property and financial affairs, at a time when you can no longer make decisions for yourself. With a power of attorney document, I say that you should view it where you've got capacity as a bit like an insurance policy. Hopefully it never needs to be relied on. And under the Mental Capacity Act 2005, you're empowered to make your own choices. But if it does need to be relied on, then we've got these legal documents there that appoints trusted individuals as your attorneys to step into your shoes and act on your behalf. Now, without powers of attorney documents, your closest blood relative can make an application to the Court of Protection to make those decisions on your behalf. Now, that Court of Protection process is a lot more complex. It's a lot more complicated to go down the Court of Protection route than to draft a power of attorney document. Now, those who don't have capacity, so those loved ones or those that we're caring for, if they don't have capacity, then the only way to write a will after the event is to make an application to the Court of Protection for what's called a statutory will. And we need to convince the Court of Protection that a will that we believe is suitable for that person, that they would endorse on behalf of the incapacitated person. So we would basically need the Court of Protection's permission to be able to make a will, a statutory will, on behalf of somebody who doesn't have capacity. Similarly, if somebody loses capacity and they don't have a power of attorney document, then an application is made to the Court of Protection to appoint what's called a deputy to act on their behalf. So as I said earlier, capacity is assessed on a decision by decision basis, and capacity tests can often be very different from a legal point of view, depending on the decision that we're looking at. So I've just outlined here the capacity test to make a will. So the law provides that a person who has the capacity to make a will, if the person can comprehend, number one, what a will is and what it actually does, two, the extent of their assets, and three, give any consideration to people who may have a greater moral obligation on their assets, or somebody who might be disgruntled if they're cut out of a will. In green at the bottom of the slide there, I do say if an individual lacks capacity, then you can ask for direction from the Court of Protection to do what's called a statutory will. Capacity test to enter into a lasting power of attorney document. It's very different to the capacity test to a will, and it's much lower, the capacity test for an LPA, than it is for a will. The question of whether the donor, which is an individual creating a lasting power of attorney document, has capacity is likely to be assessed with reference to whether the donor understands what a power of attorney document is, why they'd want to make a lasting power of attorney document, who they're appointing as their attorney, and what's the nature and scope of the powers that that individual is giving to their attorney. So you don't need to know the broad extent of your assets. You don't need to know whether somebody's going to be disgruntled, whether you're doing an LPA or not doing an LPA. The capacity test is a bit easier when an individual is executing a power of attorney document. Similarly, at the bottom of the slide there in green, it said if there isn't an LPA in place for somebody who's already lost capacity, doesn't have the capacity to make an LPA, then the only way to make a decision on their behalf is by going through the Court of Protection. I've also popped in here, a question we get asked quite regularly is, what is the capacity test to make a gift? So for example, a loved one has got the onset of dementia and they wish to now make a substantial gift to somebody within the family or a friend or a neighbour. So in terms of the law, the mental capacity required to make a gift is the capacity to understand the nature of the transaction when it is explained to the person making the gift, and the level of understanding required depends on the circumstances of the transaction. So If somebody is a multimillionaire and they want to give away £10,000, and they can understand that is a small part of their estate that they want to give away, then the capacity test for that is lower than if somebody wants to give away their family home, which is worth £200,000, and that's the only asset that belongs to them. So it is the capacity test to make a gift is on a gift by gift basis, and it does largely depend on what the overall makeup of their estate is and what their understanding of making that gift results in. Under Law Society guidelines, as solicitors, if somebody comes to us and they want to make a gift and there is an impairment of the mind, then it is prudent to obtain a second opinion from a medical professional, and particularly where there isn't that history there with the client. So if we've known a client for a long time, and where I've acted for clients for over 15 years, and I know the extent of their assets and I know the extent of their understanding of their wealth and who's in the family, then it might be an easier decision for me to assess the capacity to make a certain gift if that person's onset of dementia. But similarly, if somebody comes to us cold and we don't have that history, then we do need to make sure that we are crossing the T's and dotting the I's in that regard. If the individual lacks capacity to make a specific gift, then we need authorization from the Court of Protection. Even if there is a power of attorney document in place, you still need the authorization of the Court of Protection to make gifts if the person lacks capacity. Okay. Now I'm going to touch on the role of the Court of Protection. So Court of Protection make decisions in relation to finances and health and welfare matters for people who can't make decisions for themselves. So Court of Protection intervene, or we can make applications to the Court of Protection when an individual lacks mental capacity. They're responsible for deciding whether someone has the mental capacity to make a particular decision for themselves. They have the power to appoint deputies where there is no power of attorney document. They can make one-off decisions on behalf of an individual. So for example, where an individual wants life-sustaining treatment or they don't, and they don't have any other document in place, Court of Protection can make those kind of decisions. They can handle urgent and emergency applications. They can make decisions about the validity or registration of disputed powers of attorney documents. They can consider applications in relation to statutory wills where a person doesn't have a will, where the closest person to the individual who lacks capacity wants to change their will, then they can consider applications in relation to a statutory will. They can also consider applications in relation to making gifts. Finally, they can make decisions about when someone can be deprived of their liberty under the Mental Capacity Act. So these deprivation of liberty orders, and when they are being disputed, you can ask the Court of Protection for direction. Court of Protection is different to what's called the Office of the Public Guardian. So the Office of the Public Guardian is an organisation which in the first instance, they control the use of lasting powers of attorney documents. So their purpose is to stay in control of decisions about health and finance and make important decisions for others who cannot decide for themselves. They're responsible for taking actions where there are concerns about an attorney, a deputy, or a guardian. They are responsible for registering lasting and enduring powers of attorney documents so people can choose who they want to make decisions for them. They maintain the register of attorneys, deputies, and guardians. They supervise deputies and guardians and make sure that they're carrying out their legal duties as they should be. And they look into reports of abuse against registered attorneys, deputies, or guardians. Now, one thing that I should have said earlier is lasting powers of attorney documents were replaced by the old style enduring powers of attorney documents in 2007. So anybody who made an old style enduring power of attorney document prior to 2007, they continue to be valid. But after 2007, you could only do lasting powers of attorney documents. But the functionality of both of these forms are identical from a finances point of view. So under an enduring power of attorney document or a financial lasting power of attorney document, you appoint attorneys on your behalf to step into your shoes, operate your finances on your behalf if you're no longer able to. What the old style enduring powers of attorney documents didn't cater for is your health. Whereas there is an additional form which is called a lasting power of attorney document in relation to your health and welfare. And that does allow for you to appoint an attorney to make decisions in relation to your health. And for example, I appoint my husband and my brother as my attorneys on my behalf in relation to my finances and in relation to my health and welfare. That they can make decisions in relation to life-sustaining treatment, where and how I should be cared for if I lose capacity. Like I said earlier, it almost should be viewed a bit like an insurance policy. Hopefully it never needs to be relied on, but anything could happen at any time, which could result in a lack of capacity and lack of being able to make decisions at the pertinent time. Okay. So one of the services that we do offer is we offer everyone a free will review, a free power of attorney document review, or review of court protection papers that they've got. So if somebody wanted us to cast eyes over any legal documentation that they've got, then we're more than happy to give individuals a peace of mind of something that they might have drafted themselves, and they just want another pair of eyes. If we believe that it's legally inaccurate, or they need more support and more guidance, then we'd be transparent in relation to the process and offer support in that regard. So that is everything in a nutshell that I wanted to talk about today, just to give you an overview of things that I see day to day. And we're more than happy to answer any questions that individuals have got.
That's brilliant. Thank you, Taz. Oh, that was a lot of information. I was busy scrolling it down. You know what I wanted to know? Like, if you put an LPA in, how long does it take
to get it registered?
Yeah.
So in terms of the kind of form filling process, that can just take a couple of weeks maximum, as long as the attorneys and the donors are available. Then we send it off to the Office of the Public Guardian for it to be registered. It can't be used until it's been registered. And that registration process, the OPG themselves say takes 6 weeks, but it depends on how busy they are. They are a government organisation. We've had some that took 3 months to come back to us. So we say allow up to 3 months.
Right. Thank you for that. And if you had to go through the Court of Protection as a deputy, it feels like that would be a much longer process.
Yeah, so we usually say allow 6 months. We can try and with urgent applications try and hurry certain things along, but they are inundated with lots and lots of requests. And so that court of protection process does take a lot longer than a power of attorney document does.
Thank you. Right, we've got some questions. Normally I'm saying, right, put your questions in, everyone, but we've got some questions already. So Karen has said, what's the difference? Oh, well, okay. Difference between an enduring and a lasting power of attorney, please. We have covered that very well. Taz, did you spot that question come up, or did you just?
No, I didn't actually.
That's so smooth. So Keith has said, when a person is deemed to have lost capacity to make decisions, but no test been done, how do you challenge the decision? When a person is deemed but no test been done, how do you how do you challenge? So how do you challenge if somebody's saying you've lacked capacity and you're thinking I haven't lacked capacity? How do you challenge it?
Right. Okay. If a third party is saying it about you, then the first thing that I would do is go to your GP and get your GP to put on record that they don't think that you've got any capacity issues. So it'd be on your medical records. And if anybody tries to contravene that, just say, speak to my GP.
Brilliant. Okay, got a long one here. My mother-in-law is currently in a residential home. She's been assessed by a person appointed by the solicitor as not having the mental capacity to understand the consequences of her decisions that affect her health and well-being. The residential home already have her dolls regarding her welfare because she insists she can go home and look after herself. The solicitor we've appointed is handling the COP. If she still insists on coming home, what can we do? Can we sell our house and have a suitable extension to our house that is specifically for her? Ooh.
Okay. If she still insists on coming home, what can we do?
She doesn't have, there's an extra bit. My mother-in-law has still not officially been assessed as having dementia. Okay.
Right. So if there are a number of organisations or a number of people who are saying that that individual doesn't have capacity to make their own choices, then we can make decisions on their behalf. So it looks like the care home have already put the dolls in place, the solicitor's already assessed capacity, and it might be that there's adult social services involved as well. So if that individual is deemed to lack capacity themselves by all of these other professionals, then you just have to be led by those professionals in terms of making decisions on that in the individual's behalf. Now, if the individual disagrees, then they can make an application to the Court of Protection or speak to their own GP and see if there's somebody that would support them in saying that they do have capacity when there is a conflict. In a situation like this, it's highly unlikely that mother-in-law will be able to do that, because it seems like there's lots of people there already making quite strong decisions in relation to capacity on her behalf anyway. So it'd be very hard to challenge it. Solicitors are inherently cautious before they decide that somebody's completely lack capacity. Because as I explained, under the Mental Capacity Act, you are deemed to have capacity, unless somebody can categorically decide why you don't have capacity. So using that as a starting point, solicitors are probably very cautious in the first place. The fact that they have asserted that they don't have capacity, it's unlikely that she'll be able to make that decision for herself. So I hope that answers the question.
Thanks, Taz. And I don't think we talked about dolls. And I just wondered, did we talk about dolls?
Very briefly. So the deprivation of liberty orders. So there's certain institutions that can put them in place if they believe it's in the best interests of an individual. They can also be challenged. So they can be challenged by that individual who the doll is against. They can be challenged by family members. They're difficult to challenge, and they don't have to last indefinitely. So it's not my personal area of expertise to deal with dolls. We know about them in the context of our clients, and we tend to work with the authorities, so work with the care home or adult social services, the doctors, the clinicians to ascertain the terms of that dolls at that time.
Okay, thank you. Carolyn said, should everyone have an LPA?
Absolutely. I think irrespective of age, anyone who's got assets, or anyone who wants a loved one to make decisions in relation to their welfare should have a power of attorney document in place. I say view it like an insurance policy. Hopefully it never has to be used. But as a practitioner who's been doing this for over 15 years, we see the most horrendous of stories in practice. So things like car accidents, brain tumours, brain injuries can happen overnight. And once somebody's lost capacity, then it's too late. You can't do an LPA. So everyone should have one irrespective of age.
And because I'm a penny pincher, Taz, I got the impression I could have a go at writing my own LPA, and I could say, hey, Taz, have a look at this. And you go, yeah, actually, Emma, that's half decent. Send it in. Is that right?
Absolutely. Yes. And we give that advice to clients all the time. Go online, do it yourself if you've got the patience and the inclination to do it. They are about 20-page forms. So some clients will go online, look at it and go, oh, don't want to touch that. You do it for me. And then other clients will go, actually, I've got the patience to do that, and I don't want to spend £750 with you. Thank you very much, Tas. So and we give clients that option, and we're more than happy to skim over documents that people have drafted themselves just to give them a bit of a once over. Now, if it's going to take us more than 5 or 10 minutes for somebody that we don't know, then I would need to be honest about the fact that, look, this is written with mistakes and it does need a redraft, and this is what our charges would be. So it's I'm not asking hundreds of people to come to me and I'll check their powers of attorney documents. But if it's a 5-minute job, then more than happy to look at it and give you the seal of approval.
Brilliant, thank you. And now Marie's asked something else. She said, my father-in-law has Alzheimer's, vascular dementia, and is being looked after at home. He lives with his stepson who works full time. What if my father-in-law needs to go into care?
So I would involve kind of adult social services in those conversations, or the GP. And if the individual does need to go into care, then they'll be assessed in relation to their finances and in relation to their health to see what level of care is required, and the team of clinicians at that point will decide what's in father-in-law's best interests.
And I suppose I'd be asking, is there an LPA? Have we got an LPA?
That is absolutely.
Okay. Sarah said, is it best to register the LPA before the person loses mental capacity? We see people who have done the paperwork but not registered it.
Yeah, I always advise, I don't like doing LPAs without registering them. I always advise to get them registered at the outset. Yes, it costs £82 per form. And if you change your mind about the choice of attorneys, then you've got to pay the £82 again. But it can take up to 3 months to get them registered. So at the time that you want to go and use them, and then you've got to wait 3 months, it's just a bit of a practical nightmare. So I do say at the time that you're creating it, get it registered, and then it's done and dusted.
And I really like how you sort of say you think of it as an insurance policy. So like that and the will, you know, it's just something that you need there. It's helped in my head to sort of think, I might be doing that over the bank holiday.
I'll look at it for you, Emma, don't worry.
We're friends now.
Absolutely.
So Karen has said, thanks for all the information. When Mum went into a home, both myself and husband attended solicitors and we have an LPA in place. This doesn't appear to be a joint LPA. Is this an issue? Does this mean that either he can decide something without me and vice versa? Oh.
So both myself and her husband attended solicitors.
So separate.
Right. So it looks like Mum's husband and daughter are appointed as, and Karen are appointed as joint and several attorneys. So that means that either of you can make a decision independently of one another. But you've got to give attention to the Mental Capacity Act, in that you've got to make decisions that is in Mum's best interests at all times. If there's a conflict between two attorneys, if Mum's husband's going off on a tangent and doing something that Karen's not happy about, then she should absolutely address that, either with him directly and say, I don't think this is in Mum's best interests, or report it to the Office of the Public Guardian if you're concerned. So attorneys should be on the same page. Doesn't always happen. Attorneys can have differences of opinion, but what I would also advise is to liaise with the clinicians who might be involved in Mum's care, whether it's adult social services, whether it's Mum's GP, whoever it is, and to get them on side to ensure that the decisions that you're making are definitely in Mum's best interests if there is a conflict between two attorneys. If the conflict can't be resolved, then the Office of the Public Guardian are there to support attorneys with differences of opinion. Now, I never recommend that attorneys are appointed jointly. And the reason being, if you and Mum's husband were appointed as joint attorneys, then that means that you would both have to make decisions together at all times. Now, if Mum's husband lost capacity himself or passed away, then the power is not worth the paper's not worth the power that it's written on. So it invalidates the LPA in its entirety. So where you're appointed jointly and severally, it means that you can act independently if you want to, but jointly if you'd like to as well. So it's a better way of appointing attorneys.
Thank you for that one. And Marie said, are there any solicitors who do free wills and LPAs for a donation to a charity?
So we absolutely do. We partake in Will Aid, which is the full month of November every year, where we do free wills for charities. And then we also partake in a few others as well. We work with the Christie and a few other charities as well. So there are a number of them. You just need to be on the lookout and just savvy as to which solicitors are assigned to what charity. But certainly in November, as JMW, we do offer free basic wills in return for suggested donations to charity.
Just putting a note in my calendar
For November. And maybe we can do something with Age UK at some point as well, Emma.
Oh, hey, that would be amazing. That would be really good. So in my head, the office of the Guardians is just like filled with men with that are like 2,000 years old with like giant beards. That's how I've got it in my head, and I can't get it out of my head.
So they are a government organisation. They can be sometimes a little bit draconian. If somebody's from the Office of the Public Guardian is watching, I'm sorry. But they are there to offer support and guidance to people who are doing powers of attorney documents and for attorneys who are concerned. And the majority of the times they do a great job.
Brilliant. We've come right. Come on, any more questions? We've still 20 minutes left. Otherwise, this will be the quickest, most efficient webinar. There's another question. Jen, I've used Will Aid November. It's fab. Oh, there you go, Jen. Nice one.
I know, I'm sorry I didn't know where to my first presentation was really long. I thought I was practicing it went on, and so I reduced it a bit.
No, don't worry. No, it's good. It's good. It's sort of succinct. It's everything that we need to know. Very quick. So Tas, just a little bit about support. So one of the big things that we see is someone goes into hospital, they go into a care home for assessment, they don't come out of that care home, and then you get this sort of messy bit of like who's going to pick up the fees and who, like all of that becomes quite hard and stressful for families. Is that something that you can support with?
Yeah, absolutely. So, we do look at first things first, who is the appointed attorney, and hopefully there is an attorney in place who can immediately access funds and support the family through that. And then we have kind of a disregard period where you've got the local authority picking up the tab for a certain number of weeks. And then if somebody's very poorly, then you've got clinical commissioning groups, so CHC, funding, which through the NHS, which individuals can qualify for. And there sometimes can be a bit of a conflict as to, who certain social workers will say, well, this individual definitely qualifies for the NHS CHC funding. And then the NHS is saying, well, no, we don't think that they qualify for that funding. So we can look at it objectively and make a view on it and insist on the right assessments being done at the right level, at the right time, and support the families through that. It can get quite complicated.
Just from experience from talking to people, it feels like the local authority money comes in pretty quick, and then it's a battle to get any NHS money.
That's right. And it's the families who unfortunately are kind of fighting the fight and take, really pushing for that money to come through and that assessment to be done, are the ones who tend to be successful, the ones who are persevering and keeping at it, and then the ones who kind of give up the fight end up either self-funding or appointing solicitors, which makes it kind of longer and costly as well, unfortunately. But it's just one of those systems that does need smartening up a bit. I know there is talk in Parliament about the Care Bill and the Care Act and trying to put more policies and procedures in place, but at the moment we're not there.
Yeah. So real. I watched something about Japan, and they pay into the care system big style, so that when they need the care system at the end, oh my God, that is a good care system that they're getting. Whereas here, it's sort of cheap and cheerful, and actually, it's not cheerful at the end, is it? When you actually need that support.
No, and we do pay so much in taxes, but it's there doesn't seem to be that pot at the end, and then people who have worked very hard to pay off their mortgages almost feel like they're being penalised and forced to sell their homes to pay for care costs. And it's very sad. And then you see people in care homes in rooms next door to each other, where one person's not contributed towards any taxes or towards the state for their entire lives, and the other person's forcibly having their homes taken off them to fund their care costs. There is a huge disparity, and I know the government have been doing these initial proposals for many years now, and it's kind of in the back of the queue again, but hopefully it'll come at the forefront again at some point.
I'm not sure if we've sort of talked this through already, but a lot of carers, this from Rachel, one of my colleagues, a lot of carers we support are worried about care home fees. Do you have any guidance on this?
We do. It's very much dependent on each family's personal situation. The starting point is that you can't be seen to deprive a local authority of assets. So if I knew I had a degenerative diagnosis and I owned my own home, which was worth £200,000, and I had £100,000 in the bank, and I knew that care was imminent, and I transferred my home into my son's name and I got rid of all my cash, then that could be viewed, I could be criticised for deliberately depriving the local authority of assets. Within the same breath, I can do estate planning. So if I am fit and healthy and care is not imminent and I never want to go into a care home and I want to genuinely divest myself of my assets and support the next generation who are finding it harder to get on the property ladder, who need that additional support because it is harder on them than it was on us when we were buying our first homes, then there are things that you could do from an estate planning point of view, but the primary motive cannot be to avoid care costs. If that's your primary motive, then I'm afraid it doesn't work. But if you want to support your family and you want to do some estate planning to help them, and inadvertently it deprives your estates of assets, then that's allowed. But that can't be the main motive.
Yeah, thank you. Marie's, we've been informed that if a person's savings go under 23,000, the cost is covered by the local council. Is that correct?
That is correct. So on a sliding scale of between £14,250 to £23,250, 23,250 tends to be the capital amount, 14,250 tends to be the kind of liquid capital amount. So it's the contribution varies in between those amounts. The maximum amount you're allowed to keep to pass on to next generation is 14,250. But they start contributing at 23,250.
Right. Okay. I think I've got that.
I know it's a bit complicated.
We've recorded it though, so Masood, yeah, we are recording this and we will be popping it on YouTube for you to watch again. So it'll be up there, I don't know, by tomorrow probably. Okay, so I'm just going to ask, are there any more questions? And if not, I'm going to say thank you and wish you all a lovely afternoon. So I'll give you a second just to think. I'm going to open up the polls. Let me do something. Right, I've just opened up the polls, so let us know how you found today's webinar. We have another webinar booked in for the 9th of June, which is with Penny Folds and Sharon Bolter, and it's in Carers Week, and they're going to be talking about research. Oh, okay. Paul's asked, who's responsible for the fees in a home patient or in a home, patient or the family? Who's responsible for the fees in a home, the patient or the family?
The patient. So it's the patient's funds that you look at. Now, if a family sign an agreement, a third party agreement or a top-up agreement, then they can take on the liability of the home, of the patient. But the starting point is that it's just the patient's liability.
So, okay, that's made me think. So I'm a couple, so there's two of us, and I need to go in a home. Does that mean my partner has to sell the house to cover the costs of that? No.
No, because but your value of the house can be taken into consideration for the purposes of care costs. So if you own half the share of the family home, then that half share, the local authority can put a charge against, or the council can put a charge against your half share, but they won't forcibly kick somebody out who's living in there. There are some kind of protected characteristics in that regard, but if it was an unoccupied property, then they can force the sale of that property, but it's only your personal asset. So if between you and your partner, if you had 100,000 in savings and it was all in his name and you needed to go into care, then they can't touch his savings. It's only your personal assets that they can touch.
But if we're a house that we both own and say it's 200,000, 100,000 of that could go, but that would mean, so I'm not going to get kicked out, but maybe when I die, that's when they cash that in. Is that right?
That's right.
Okay.
Yeah.
Because I think I hear that quite a lot. People worried that they're going to lose their homes. So
not while they're living there, no. But after, when it's unoccupied, then they can put charges against properties.
Right. Maria said, some homes ask for an extra payment of £75. We came across this when looking for a suitable home for my mother-in-law.
They do. I think it's private care homes, and they want supplements for additional services that they offer, but you've got a choice there as to whether you send them there or not.
Oh, so that's a top up basically. So the state will pay X, but then they want a top up of £75.
Exactly.
Which doesn't sound much, does it? But it's per week, and then over the years, that really starts to add up.
Yeah.
Okay, everyone, I'm going to give you a final warning on questions. Oh. Okay, so Carolyn's asked, does the charge on the house have to be indicated?
Have to be?
Indicated. Does the charge on the house have to be indicated?
So I can't see the question. Well, yes, insofar as if the local authority, the council, are going to go and put a charge on somebody's property, then that charge needs to appear at the land registry, and the patient and person living with dementia or their family should be informed about it. And they've got the right to object if they think it's incorrect. Okay.
So you can fight that. So like if the local authority came to me and they said, right, no, we want half of that house, we won't take it now, but I could come to you and say, Taz, they're trying to take half my house, and we could fight it.
Absolutely. Yeah.
Would we win?
Depends on so if it's your husband who's going into care and it's his half of the house that they're putting the charge on against, then unlikely to. But if there's an outstanding mortgage, if there are other considerations that we need to take into account, that there's more debts than there are assets, etc., then we can look at that. Yeah, we're likely to win. Okay.
So because I threatened them, they've all put loads of questions in now. So Anna said, so if a family refused to pay the top up with the will the extras be refused to the resident?
Yeah, usually. Usually the care home don't accept them if the family are refusing to pay the top up, but they are conversations that you should be having with the care home directly.
Yeah, so they would just refuse them. It's not as if someone would just be having cheese sandwiches while someone next to them would be getting a 3-course meal. It wouldn't even get into the care home.
Yeah, that's certainly my experience over the last 15 years. Yeah.
Right. And then Paul said, my wife has a reasonable pension, but due to lack of an LPA is unable to access it. What can a home do about that? Okay, well, what can a home do about that?
Okay, so his wife in a care home?
No, so wife's at home. They don't have an LPA, so his wife can't but due to lack of an LPA is unable to access it. What can a home do about that? Should we ask Paul just to clarify that question for us?
Oh, sorry, I can see the question now. So, my wife has a reasonable pension, but due to a lack of LPA is unable to access it. What can a home do about that? So I'm assuming wife is in a home.
No, so wife's at home with him. I think it's just like in the future, what could a home, could somebody take that money?
Right, okay. So if all pension income, well, not all pension income, there's somebody, okay, it's a bit of a complicated answer. If Paul and his wife are reliant on the income from the pension, and that is coming into, for example, the joint bank account, and they are using that to run their family home, then a care home is not entitled to all of the income there, but they might be entitled to some of it. So if the wife ends up in care, then their income is assessed to contribute towards the cost of their care. It might be a percentage of that income, or half of the income, for example. So half of it might belong to Paul and the other half belongs to the wife. Now, the local authority will want to see, or the council will want to see, how they can get access to that money. So without an LPA, the only way to get access to that money is the court of protection. So either the local authority can instigate the court of protection process if Paul can't do it himself, or Paul can instigate the court of protection process without an LPA. As soon as you've got that court of protection application, the court of protection court order allowing you to access your wife's pension, then that gives you the clear legal authority to access her pension and pay what is accessible towards the cost of her care, because there will be a chunk of that pension that she has to contribute towards the cost of her care.
Right. So it feels a bit like Paul he doesn't have an LPA, so one of his first actions maybe would be to get a deputy, so to apply to be a deputy. Is that right?
That's right.
Other things would follow.
That's right. Yeah. If wife doesn't have the capacity to do an LPA anymore. Yeah. So then he should make an application to become a deputy on behalf of wife through the court of protection, which he can do himself using the online forms.
Brilliant. Okay. Marie, my father-in-law has left a will covering my husband, his stepson, and his other two stepsons. If he went into a home, what could we do? So I'm assuming Marie means there that if all of the assets are used towards the cost of care. So if all of I'm afraid nothing. So a will just says whatever is left over, whatever I own as of the date of my death, is passed to these individuals that I've nominated in my will. If there's nothing left, then I'm afraid those individuals don't get anything. And the only way that could have been avoided would have been estate management, that sort of planning.
Exactly. So if somebody had the foresight to do estate planning and put assets into different people's names or gift them parts of their estate while they were fit and healthy, while care wasn't imminent, then those assets are always protected. But anything that's in their estate and they end up in care and it's accessible towards the cost of their care, and they've got no money left other than this maximum amount which you're allowed to keep, which is £14,250, then the rest of it gets eaten up in care costs, I'm afraid.
And Sam has sort of continued that story. So what if the person in care owns the property just in their name? So my partner owned the house, they've gone into care, I'm in the house, we are married. What happens in that case?
You've still got occupiers' rights. So while you're in the property, but they can put a charge against the property, against the entire value of the property.
So I'm not going to get turfed out. Again, I wouldn't be turfed out, but when I die, we wouldn't be passing anything on because it would probably just be sucked up in care costs.
Yeah. Yeah.
Okay. And then Karen has said, if my stepdad is currently paying £150 top up for the care home mum is in, if something happens to him, would they look to family to continue paying this? Could they insist she moves to a home that doesn't require a top-up? Ooh.
So yes, they could, because that care home in a way is losing out of this £150 top up that they've asked for. So they've said mum can come here as long as they pay, as long as the family agree to pay the top up. So there's a contractual obligation that stepdad has signed to pay that top up. Now, it would be very unfair for the care home just to kick the person out because the family can't afford to pay the top up. But unfortunately, it does happen. So it doesn't happen that often, because a lot of care homes do tend to be more sympathetic of the situation, but it still can happen. So I'm afraid we are where we are in that regard, and it's up to the goodwill of the owners of the care home to decide whether they continue or whether they say no.
Taz, I think you've broken a record today. 24 questions. I think that is a record in one webinar. So thank you so much for your time. It's really, really, wow. My head's full. I imagine everybody else's heads are full, but I think just teasing through those questions and just helping people work out, what's what has been so useful. Rachel said, wonderful session, Taz. Thank you. And Kath has said, thank you, excellent session. Well, this is where they all come in saying thank you. Thank you for sharing all your knowledge and being so honest. Thank you so much. Lots of information. Yeah, lots of information. What I'll do is I will include the link to the YouTube in the email that everybody gets tomorrow. So if you need to just come back on something and watch it again, it'll be there for you. Okay. That was amazing, Taz. I'll see you again in November.
Emma, please do.
I'll get my LPA in first. I'll do that sort of maybe like August, September, and then I'll pop up again in November for my will.
My pleasure. Absolutely my pleasure.
It has been absolutely wonderful. I'm just checking there's no more questions. We are drawing it. Oh, James is coming with the last one. Does 14,250 cover funeral expenses? Can you put that aside and then have the additional 14,250? No.
I'm afraid not. No. I know sometimes funeral plans work better for that. Sometimes because you can pay for a funeral plan. Again, bit controversial, so you should be paying for it when you've got capacity and you're fit and well, really. But an attorney can sometimes pay for it because they can deem it to be in the best interest of the donor. But you can't have that as an additional cash sum just sat there in your bank account.
But what James could do, so he could, if his amount is more than 14,000, he could pay for his funeral plan now.
Yeah.
And so that's all covered. It's paid over there. He knows that's sorted. And then then he still gets his 14,250. Yeah.
That's right. But if you're doing that on behalf of somebody who's completely incapacitated and they're in care, then that's a bit of a grey area. When you're doing it for yourself and you've got the capacity to do that, then you're allowed to spend your money as you want to spend your money. But when you're doing it on behalf of somebody who's completely incapacitated and they're in care and they're teetering on that point of only having 17,000 left in their account, then I'm afraid that's when it can be seen as deliberately trying to deprive the local authority of assets by quickly buying a funeral plan. So the timings of it are sometimes a bit key.
So it's back to planning again, isn't it? So if it's that future planning. So if you do have cash there and you're worried about your funeral, you can future plan that and you can pay for that now.
Absolutely. Yeah.
Brilliant. We've gone over by 1 minute because we've gone 26 questions. Taz, thank you so much for your time. Thank you everyone for coming along today, for all your amazing questions. I will see you very soon. I'm going to end it now and say thank you all again.